Good day, everyone. Hi, my name is Bai-Ali as Ankie together with my partner Johannah Mae Tekoken. Our report is all about the Republic Act 2262, the Anti-Violation Against Women and Their Children Act of 2004. So before we proceed to the definition, we may first introduce the declaration of the policy. So it is perfectly clear that the state value the dignity of women and the children and guarantees full respect for human rights. The state also recognizes the need to protect the family and its members, particularly women and children, from violence and threat to their personal safety and security. So towards this end, the state shall exert effort to address violence committed against women and children in keeping with the fundamental freedom guaranteed under the Constitution of the provisions of the Universal Declaration of Human Rights, the Convention on the Elimination of All Forms of Discrimination Against Women, Convention on the Rights of the Child, and other international human rights instrument of which the Philippines is a party. So let's move on to the definition of violence against women and their children, or the VAWC. Any act or series of acts committed by any person, male or woman, against a woman who is his wife, former wife, or with whom the person has the sexual or dating relationship, or with whom has a common child, or against her child within or outside the residence, a VAWC which result or any likely to result in physical, sexual, or psychological harm or suffering, economical abuse including threats or such act, battery, assault, coercion, harassment, or arbitrary deprivation of liberty, who are protected, women and the children. So there's 4 types of violence punishable under this law. We have the physical violence. From the word physical, we have physical injuries, and as you can see as the figure, the physical injuries, mutilation, or an act that include bodily or physical harm. It is include but not limited to rape, sexual harassment, act of lascivious, or threatening a woman or a child as a sex object, or making demanding and sexual subjective remarks. So it also includes forcing the woman or her child to do an indecent or indecent act, and so on. We have the psychological violence, an act or omission causing or likely to cause mental and emotional suffering. It is more on mental health. So it is include stalking, damage or property, ridicule or repeated verbal abuse, depriving the woman of access to her family, marital infidelity. It is also include causing or allowing the victim to witness the physical or the sexual or psychological abuse of a member of the family to which the victims belong, or to witness pornography in any form of witness abusive injuries to pets, or to unlawful or unwanted deprivation of the right to custody and visitation of a common children. And that's all. So we have the sexual violence, or the forcing the woman to watch obscene movie, forcing a woman to engage in any sexual act, and an act which is sexual in nature or committed against a woman or a child. From the word sexual abuse or violence, we have the economical abuse, or an act that makes or attempt to make a woman financially dependent, including a withdrawal or financial support, preventing her from engaging in any legitimate professions, business, or activity, or the deprivation or threat of deprivation of financial resources and the rights to use consensual on community property, or serious immoral grounds as defined in Article 73 of the Family Code. Here are some frequently questioned under this law. So define children as use under RA, or the 9262. Children refers to those below 18 years of age or older but are incapable of taking care of themselves as defined under Republic Act number 7610. As used in this act, it is included the biological children of the victim and other children under her care. Define dating relationship as used under RA 9262. It is a situation wherein the parties live as husband and wife without the benefit of marriage or are romantically involved over time and on the continuing basis during the course of the relationship. A casual acquaintance or ordinary socialization between two individuals in a business or social context is not a dating relationship. So define sexual relations as used under the Republic Act 2262. It is referred to a single sexual act which may or may not result in the bearing of the common child. So define battered woman syndrome. As used under the Republic Act 9262, it is referred to a scientifically defined pattern of psychological and behavior symptoms found in battered women as a result of a long history of abuse. So RA 2262 acknowledge the women who have retailed against their partner or who commit violence as a form of self-defense may have suffered from battered woman syndrome or the BWS. Any victim who suffers from BWS would be diagnosed by a psychiatrist expert of a clinic psychology. This will also help the victim in obtaining a just decision in her case. The law does not allow the offender to have custody of minor children. Their care is entrusted to the woman even she is found to have BWS.
Assalamualaikum warahmatullahi ta'ala wabarakatuh. I am Johannah Mae Tekoken from DSCE 2B and this is the continuation report of Miss Bai-Ali as Ankie. So let's proceed to the next question. Who are the persons protected by the RA 9262? So the law recognizes the unequal relations between a man and a woman in an abusive relationship where the woman is usually at a disadvantage. The following are the persons who are protected by the RA 9262. First is the wife. Next is the former wife. Then a woman with whom the offender has or had sexual relations with. A woman with whom the offender has a common child with. The legitimate or illegitimate child of the woman within or without the family abode. Next question. Is vowsy committed by men alone? Women can also be liable under the law. These are the lesbian partners, girlfriends, or former partners of the victim with whom she has or had a sexual or dating relationship. Next, what is the male spouse or partner complains about abuses committed by his wife or partner? He may file a complaint or case under the revised penal code. Next, what can women and children do under the RA 9262? So, under the law, the offended party may file a criminal action or apply for a protection order, either as an independent action or as an incident in civil or criminal action and other remedies. So, who may file a complaint under this RA? So, any citizens having personal knowledge of the circumstances involving the commission of a crime may file a complaint because violence against women and their children is considered a public crime. Where should cases for vowsy be filed? So, the cases may be filed in the regional trial court designated as family court of the place where the crime was committed. These courts have original and exclusive jurisdiction over these cases. Next, where can the protection order be enforced? The temporary protection order and the permanent protection order are enforceable anywhere in the Philippines. So, can the barangay officials mediate or conciliate, conciliation, and mediation of acts of violence against women and their children are not allowed under this law. Section 33 RA 9262 amended Section 410 to 413 of the Local Government Code. The barangay officials, police, or social workers should not attempt to mediate or influence the woman to give up her legal action or application for a BPO, TPO, or PPO. So next, what is a protection order? A protection order is an order issued under this act for the purpose of preventing further acts of violence against women or her child, and granting other relief as may be needed. The relief granted under a protection order serve the purpose of safeguarding the victim from further harm, minimizing any disruption in the victim's daily life, and facilitating the opportunity and ability of the victim to independently regain control of her life. The provisions of the protection order shall be enforced by law enforcement agencies. So, what are the various kinds of protection orders? So, we have here the various kinds of protection orders. First is the Barangay Protection Order or BPO. Refer to the protection order issued by the punong barangay ordering the perpetrator to desist from committing acts under Section 5A and B of the RA 9262. BPO shall be effected for 15 days. The Temporary Protection Orders or the TPO refers to the protection order issued by the court on the date of the filing of the application after ex parte determination that such order should be issued. The court may be granted in a TPO any, some or all of the reliefs mentioned in RA 9262 and shall be effective for 30 days. The court shall order the immediate personal service of the TPO on the respondent by the court sheriff who may obtain the assistance of law enforcement agencies for the service. Next is the Permanent Protection Order or the PPO. Refers to the protection order issued by the court after notice and hearing. The court shall not deny the issuance of protection order on the basis of the lapse of time between the act of violence and the filing of the application. PPO shall be effective until revoked by the court upon application of the person in whose favor it was issued. So, where can I apply for a protection order? So, for the application for a protection may be filed with the appropriate regional trial court or family court or municipal court where the petitioner resides in case of temporary protection order and permanent protection order, respectively. Barangay protection order may be applied for in the barangay where the applicant resides or in accordance with Section 409 of the Local Government Code of 1991. So next, who may file a petition for protection orders? A petition for protection order may be filed by the following: the offended party, the parents or guardians of the offended party, the descendants or collateral relatives within the fourth civil degree of consanguinity or affinity, officers or social workers of the DSWD or social workers of local government units or the LGUs, police officers, preferably those in charge of women and children's desk, the punong barangay or barangay kagawad, lawyer, counselor, therapist, or healthcare provider of the petitioner, at least 2 concerned responsible citizens of the city or municipality where the violence against women and their children occurred and who has personal knowledge of the offense committed. So, how can I apply for a protection order? The application of the protection order must be in writing, signed and verified under oath by the applicant. A standard protection order application form written in English with translation to the major languages, which is readily available, shall contain the following information: the names and addresses of the petitioner and the respondent, description of relationship between the petitioner and respondent, statement of the circumstances of abuse, description of the reliefs requested by the petitioner, requested for counsel and reasons for such, request for waiver of application fees until hearing, an attestation that there is no pending application for a protection order in another court. So what can the woman do if the barangay official failed or refused to issue the BPO within 24 hours from application? So first, she can file an administrative complaint against the barangay official for failure to perform his or her duties. The complaint must be filed with the Sangguniang Panglungsod or Bayan. Next, she can go to the police station to complain against the perpetrator. Next, she can go to clerk of court of the family court where she lives and request assistance in filing for a protection order. That's all. Shukran and wassalam.
The last part of our report is the penalties. The crime of violence against women and their children under Section 5 hereof shall be punished according to the following rule. The first one is the act falling under the Section 5A, constitution attempted or frustrated or consummated parricide or murder or homicide shall be punished in accordance with the provision of the revised penal code. If this act resulted in mutilations, it shall be punishable in accordance with the revised penal code. Those constellation serious physical injuries shall have the penalty of prison mayor. Those constellation less serious physical injuries shall be punished by prison correctional, and those constitution slight physical injuries shall be punished by arresto mayor. So, act falling under Section 5B shall be punished by the imprisonment of 2 degrees lower than the prescribed penalty for the consummated crime as is specific in the preceding paragraph, but shall in no case be lower than arresto mayor. Number B is to act falling under Section 5C and D shall be punished by arresto mayor. Letter C or the number 3, act falling under Section 5E shall be punished by a prison correctional. The number 4 or the letter D, act falling under Section 5F shall be punished by arresto mayor. The number 6 or the E or the 5 rather, act falling under Section 5G shall be punished by prison mayor. And the F or the 6, act falling under Section 5H and Section 5I shall be punished by a prison mayor. If the act are committed while the woman or the child is pregnant or committed in the presence of the child, the penalty to be applied shall be the maximum period of penalty prescribed in the section.